Mr. Martin, it's not required that you would say anything today, but it is allowed. Is there anything you want to tell me or no?
Yes, sir. Like I said in that letter, I stand before you today, a young man ready to accept the consequences for his actions, and I accept full responsibility for what I've done. I'm really ready to just move forward past all this and start this next chapter of my life and be a better partner to my significant other and a positive father figure for my child once he comes. Thank you.
Thank you. Mr. Rich, people's recommendation.
Thank you, Your Honor. The defendant is 25 years old. At that young age,
He stands in court, claiming responsibility, promising change. But the record tells a different story. In this courtroom, words mean nothing without action, and the judge knows it.
5 felonies and 4 misdemeanors, which is significant for such a young age. He's here to be sentenced on a possession and delivery of pleas. He has made choices after being offered previous services of probation and incarceration, and here we are today, the second one being committed while he's on bond for the first. I know that sometimes people think, oh, well, having a child changes things, but there's probate courtrooms full of cases where people still continue to make bad choices despite having children. Oftentimes you have to make that decision first for yourself before you can help others or be anything for others. And I think that by Mr. Martin's actions and choices, that the court should follow the recommendation, and I believe that it should be ordered consecutively. Thank you.
Thank you, Mr. Martin. If you please stand for the court sentence. Mr. Martin, you know, your lawyer's done a great job for you throughout this case, and you haven't really made your job all that easy. While you've got a pending case for possession with intent to deliver methamphetamine, and should get you an outcome down to a possession, you're still out there while you're on bond for a serious felony, and you're out there selling drugs. And saying gets a controlled buy-in to you while you're on bond in a drug case. That's just a spectacularly terrible decision. When I kind of back up and look at this case, you were, your last sentence was 3 years in prison. So you're on parole from a sentence where you went to prison for 3 years. While on parole, you're involved with Mr. Sayers with you know, enough methamphetamine that it was intent to deliver for sure, and then, you know, the degree to which you're participating in the chase may be unclear, but you're definitely not a kidnapping victim here. You're tossing the drugs out the window. You know, you're running wild out there while you're on parole. And then while you're on bond for that case, you end up, I don't know, there was a parole detainer, and then I think when they discharged it, well, yeah, so then they finally discharged you from parole, which Lord knows why the Department of Corrections would discharge you from parole when you committed a felony crime while on parole. I don't know why they don't wait around and, you know, maybe return you to prison, but I think they like to say that their recidivism numbers are so low, they didn't return you to prison. You had a successful parole. Well, you had anything but a successful parole because you're out there involved in methamphetamine while you're on parole. So the parole detainer goes away and you go out in the community and you just continue to run wild and you're selling drugs and you're selling it to a CI. That's just quite a series of events, Mr. Martin. When you were on parole for a 3-year sentence, and then you're involved with methamphetamine drug activity that did involve distribution of drugs, not enough to show the 2 levels for the possession. But that's a relevant factor. And you didn't do well on bond. I dismissed a couple of show causes today, but I mean, you had some positive tests for methamphetamine and for alcohol. And then you're out there committing more crimes, deliveries while you're on bond. It's unlikely that the sentence goes less than what you had last time, right? When you get 3 years and then you behave in the way you did, usually we're going to ratchet this up a bit. So this is, I mean, there's obviously good reasons to even go above those advisory guidelines. I think that for sure, I'm very sure that upper end of that advisory guideline range is a definitely proportionate sentence given the circumstances. So in file 6767, I am going to commit you to the Michigan Department of Corrections for not less than 47 months, nor more than 15 years, exercising my discretion under the habitual offender statute to increase the statutory maximum. I'm going to give you credit for 71 days previously served after the parole detainer evaporated when they discharged you. There's also state costs of $68 and $130 in a crime victims assessment and $200 restitution. In file 6880, this is the delivery while you were on bond for the methamphetamine case. There's restitution of $70, state cost of $68, crime victims assessment of $130. And I will commit you to the Michigan Department of Corrections. Again, I think a term on the upper end of the advisory guidelines is certainly proportional for the fact that you're out there selling drugs while you're on bond for a drug case. So I'll commit you to the Michigan Department of Corrections for not less than 23 months, nor more than 7 years. It is discretionary consecutive, and Michigan does prefer concurrent sentencing, has a strong preference for that. But while somebody's on parole, involved in drugs, and then while they're on bond for that, they're selling drugs, I'm not sure there's a whole lot more cases that call out for consecutive sentencing more than that, just continuing to do that while you're involved in the system. So I'm going to exercise my discretion and run those consecutive, so you get 0 days credit on the second case. Mr. Martin, you can appeal your conviction or my sentences or both by filing an application to the Court of Appeals. If you want a lawyer, I'll give you one, but you have to ask me within 42 days. So we're going to hand you some paperwork explaining that appeal process, ask you to initial one copy for us, and the other one is for you to fill out if you want to take an appeal. Good luck to you, Mr. Martin.
Comment your opinion, like the video, and subscribe for more Real Courtroom Moments.
Promises are easy. Patterns are hard to break. When you keep choosing the streets over second chances, the court chooses for you. In the end, consequences don't negotiate.